Good afternoon, and welcome to the January webinar presented by the Recruitment, Training, and Support Center at the Federation for Children with Special Needs. My name is Janie Kreco, and I am the Training and Support Specialist at RTSC. Today's webinar, Seclusion and Restraint, What We Need to Know, is being presented by Debbie Dorfman. Debbie has been an attorney with the Center for Public Representation in Northampton since 2012. She has litigated numerous class actions and other systemic reform cases on behalf of individuals with disabilities in cases involving deinstitutionalization, access to community-based services, abuse and neglect, juvenile justice, jails, and special education. She has given numerous national and international presentations and published many law reviews and other articles on disability rights issues. Debbie graduated from the University of California at Berkeley and received her law degree from New York Law School. We are honored to have her present for us today. Our technical producer today is Renee Williams. If you are interested in learning more about the Federation, please go to our website at fcsn.org and explore all the different programs, including the Special Education Surrogate Parent Program, which sponsors these webinars. During the webinar, please type your questions in the toolbox and feel free to engage with other attendees as appropriate. I will monitor the questions as they come in, and to the extent time allows, we will try to answer them before the end of the hour. If your question is not answered live, please send us an email and we will do our best to follow up with you. Debbie, welcome, and thank you so much for being here.
Well, thank you so much, Jeannie, and everybody for inviting me. I really very much appreciate the opportunity to have the chance to talk about the new amendments to the Massachusetts School Physical Restraint Regulations. With that, I thought that we could begin with just a brief overview about what I'd like to go over today and in our discussion. At the beginning of the presentation, I just want to talk a little bit about just the growing national concerns of both mental health providers, families, and also legal advocates regarding the use of restraints in schools. And then talk about the focus of our presentation today will actually be about the new school regulations with respect to restraints in public schools, which comes under 603 CMR Section 46. We will not be talking about, and I'll discuss this a little bit more, about the other proposed amendments to some other restraint regulations in schools, but I'll explain that a little more in just a moment. And then we'll just sort of conclude with next steps with regard to the implementation of the amendments, and then conclude. And if anybody has questions, then Janie has given you some guidance about how you can ask those questions, and I'll try my best to answer them. Well, let's start out with just having a brief discussion about the growing national concerns and also concerns in the state about the use of restraints in school. There have been recently several different studies that have looked at the issue of using restraints in schools. Using restraints in schools is not an uncommon occurrence. It happens throughout the United States. Each state is different in terms of how they regulate the use of restraints and or whether they even allow them. And so there's really a wide range of different rules and regulations and laws. And so we really have to look to the state to find out, you know, what is allowed. And again, we'll talk about what's allowed or not allowed in Massachusetts, or what will be changing in when the new regulations come into play. One thing that, in spite of all of the differences, one thing that is definitely a concern is the use of these restraints throughout the United States. Many children have been very seriously injured when they've been put in restraints, and some of them have died. And certainly there are concerns that the use of restraints exacerbates mental health conditions and also already pre-existing trauma histories or causes trauma, or both. So it is a very serious concern, and there have some, if you're interested in reading some very good studies and reports about the use of restraints and the problems of the use of restraints, I would recommend that you look at the National Disability Rights Network a couple of years ago wrote a very good report, as did the Disability Rights California also has a very good report. I believe that's from 2007. And there's also a good report that came out of the General Accounting Office of the United States government that also goes over and in quite good detail the issues about using restraints and the injuries that have resulted from those. And I know that Senator Harkin also did also some inquiry into this issue fairly recently within the last year. So if people are interested in getting links to those reports, you can send an email to me. Janie can give you my email address, and I'm happy to forward you the links to those reports in case you're interested. So now we can move on and talk about what's going on here in Massachusetts with regard to school restraint. As you know, we're going to talk about the school amendments to school restraints for public schools, non-residential public schools. There have been also some changes in the regulations to the use of restraint in public and private day schools, and also there have been some that have been made with respect to the use of restraints in child care. We're not going to be focusing on those. We're just really going to focus on the ones under Section 46, which pertain to the use of restraint in non-residential schools. So there are the new amendments will go into effect on January 1st, 2016. So it's really important to know from the outset that while these are new regulations and they will go into effect, they are not yet effective. And so the current restraint regulations are the ones that are in play now and the ones that the school districts must adhere to. The school districts are encouraged to adopt these new ones sooner, but they are not obligated to do that until January 1st, 2016. So if you are doing advocacy for yourself or for others, it's important to understand that. And if you need to find copies of the current regulations, you can also contact Janie, and she can let me know and I can assist you with that. So there are several key areas that I wanted to talk about in terms of the changes that the new amendments are going to make, and they are pretty substantial changes, but the areas that we're going to cover today include the area of the definitions, the use of restraint itself, and then the notice requirements. That means the notice to parents and guardians of the use of restraint and consent as well. And then we'll also talk about monitoring and reporting requirements. That's monitoring requirements that the school district has, and also requirements that they have to report and not only tell parents but also report the use of their restraints to the Massachusetts Department of Education, Department of Elementary and Secondary Education, which is basically the state the state of Massachusetts Department of Education. And then finally, the area of training, which has also been revised fairly substantially. So let's first talk about the prohibitions and the exceptions and the limitations on the use of restraints under the new regulations. And again, reminding you these are the new regulations, not yet in play, but will be in play on January 1st. So in terms of there are several absolute prohibitions, and usually in law, lawyers have a hard time saying that something is absolutely prohibited in many situations, because for many legal rules there are many exceptions. However, I can say that under the new regulations there are 3 types of restraints that are absolutely prohibited in Massachusetts places of public education under these regulations. And that would include mechanical restraints. So a mechanical restraint is a restraint that would be like a restraint device that you would put on a child. So if there was any sort of physical device that was used to restrain a child, for example, in a psychiatric hospital they use mechanical restraints, 4-point restraints, that those may not be used in the schools. Also medication restraints and seclusion. And so we're going to talk a little bit more detail about what each one of those things are as we go through this. So we'll start with mechanical restraint. Under the new regulations, the definition of there was a definition of mechanical restraint in the previous regulations, and it was also prohibited with some exception where there was a doctor's order. But mechanical restraints in the new definitions, really the purpose of the new definitions is to clarify what is a mechanical restraint and then also what is not. And so just to be clear, again, mechanical restraint used in this context would be any sort of physical device that would be used to restrain a child or student in order to control their behavior. There are other kinds of mechanical items that are not considered mechanical restraints, that are not being used to control a child's behavior. For example, there may be a mechanical support or a support device, that, like a stander, that allows a person to be able to stand, but is not being used as a physical restraint to restrain their mobility in order to control their behavior. So that is one of the important changes in the definition that I think people should note. And we also talked about a medication restraint. In the previous regulations, it was called, there was no term called medication restraint. Rather, there was a term called chemical restraint. And under the new regulations, a medication restraint is the administration of medication that is used for the purpose of temporarily controlling behavior. And so this type of restraint is absolutely prohibited in a public education program. It's important to know that a medication restraint is not the same thing as a medication under the regulations, as a medication that's been prescribed by a licensed provider that's been authorized, and I emphasize the word "and," even though it's not underlined in the PowerPoint, that it's also been authorized by the parent or the guardian to be administered at school. So some children, for example, may take some sort of psychiatric medications on a regular basis, and that administration of that medication may need to be given during the school day. And so where that is the case, then the parent can bring a prescription to the school and ask that the school administer appropriately at the appropriate time and within the scope of the prescription, that particular medication. So that is allowed, but again, it must be with a prescription from a licensed provider, and it has to be authorized by a parent or a guardian. A school cannot decide to, for example, take that prescription and have it administered to a child outside of what the prescription allows. So if it's not if it's to be given, for example, at a certain time, and it's a medication that helps control the child's behavior, but the school feels there's some emergency and wants to administer some extra medication, they cannot do that. They also can't have their own medications that they decide to administer to the child in order to control the child's behavior. So another area of prohibition. The third item that we talked about is seclusion. Seclusion is defined under the new regulations as involuntary confinement of a student alone in a room or area for which the student is physically prevented from leaving. It's important that seclusion is not considered the same thing as a timeout. A timeout, and that's also defined under the regulations, but a timeout is really to be a behavioral strategy that can be used as long as it complies with the regulations, and that there has to be adult supervision, and it can only be for short periods of time to get to help the child calm down, but a child cannot be left in seclusion. So what this means is that if a child is having a behavioral problem, the staff cannot put the child in a room, close the door, and walk away, and so that the child can't leave the room and is unattended. That too is also prohibited from all Massachusetts public education programs. Another area, and this has been an area of a lot of concern by advocates, parents, mental health providers, and also I think the same would be true for people who are teaching for school teachers and staff, about the issue of when prone restraint can be used and when it cannot be used. So that's somewhat, it appears to be somewhat of a controversial issue here in Massachusetts. But the regulations, the new regulations, make it clear. First of all, let me just describe to you what a prone restraint is, pursuant to the definitions in the regulations. A prone restraint is a physical restraint where a school staff person is holding the child down, and the child is placed face down on the floor or on some other type of surface, and physical pressure is applied to the student's body in order to maintain the student in a face down position. So that's what a physical restraint is, a prone restraint is. One thing I just want to back up, that physical restraints, unlike the mechanical restraints and the medication restraints that we talked about earlier, physical restraints, but with the limitations that we're going to talk about in this presentation a little bit more. So we'll get to when physical restraint generally can be used, and then also specifically right now we're talking about a prone restraint, and we're going to talk about when that can and cannot be used, because prone restraints, because they are more dangerous than a regular physical restraint, they are more limited in terms of when they can be used. So we'll talk about that in just a few minutes. As I was saying, the prone restraint is prohibited in places of public education, except in the following circumstances, and it's really important. It's first of all has to be on an individualized basis, so there cannot be a policy where a school district uses prone restraints on all children who exhibit, for example, a certain type of behavior. It doesn't work like that. The decision of whether or not prone restraint can be used has to be individualized and based on the particular individual student for which that type of restraint is considered during an emergency. And some of the things that when some of the situations when a prone restraint might be allowed would be, depending on the individual circumstances of the child, would be when the student has a documented history or repeatedly causing self-injury or injury to other students or staff. All other physical types of restraint have failed, and lesser restrictive interventions have failed to ensure that the safety of students or others can be protected, and there are no medical contraindications documented by a licensed physician. All of those things have to be considered before a prone restraint can be used. And of course, this can only be used during an emergency situation when there are no other ways in which the child can be kept safe or other people can be kept safe. But there has to be, these factors have to be there. So it can't just be, again, like I said, a policy that if a child, for example, engages in hitting a staff person, that the policy is, well, we'll use a prone restraint on the child, or any type of restraint on a child for that matter. It really depends on the individual circumstances, but these are the situations when a prone restraint may be considered. There are some exceptions, I guess some additional prohibitions or considerations would be that a prone restraint would only be used when there's a psychological or behavioral justification, and that there are not any psychological behavioral contraindications to that that have been documented by a licensed or mental health professional. So, for example, if a child has a particular psychological condition, mental health condition, for which prone restraint would actually be problematic, would exacerbate that person's condition, then the prone restraint may not be used. So that would be something else to consider along with the other considerations that we talked about. Okay. In addition to the things that we've talked about, there has to be parental or guardian consent obtained to use a prone restraint. And again, it's only in an emergency when the other factors that we talked about just now have been met. And not only does there need to be guardian consent, but there also has to be the approval by the principal, and the principal has to give written approval for the prone restraint in order to be used. So those are some of the important factors and exceptions to and limitations using prone restraints. In addition, in advance of using a prone restraint, there has to be documentation of the parent's consent to use prone restraint in an emergency and the principal's approval. So those things have to be, the documentation has to be obtained, and then the school district of the school need to make sure that that documentation is maintained. So you may be asking yourself, well, what is consent? And the new regulations do discuss consent and define consent. So some key pieces of the definition is that, first of all, there has to be an agreement by the parent or the guardian, and that agreement needs to be in writing. So, for example, with the prone restraint consent, there would have to be a prior agreement by the parent saying that the parent would, in an emergency situation, permit his or her child to be subject to prone restraint. Before the parent can be asked to provide that consent, however, it's essential that the school district give the parent full information about the circumstances under which prone restraint might be considered in an emergency, what that means, and what a prone restraint actually is, and what the consequences of using a prone restraint might be. And so the parent needs to be fully informed, because in order to have consent, it has to be what we call informed consent. It also has to be voluntary, which means that the consent that the parent is giving can't be made under any sort of duress or pressure. For example, it can consent to the use of the prone restraint cannot be a condition of admission to a program or continued enrollment in a program. Also, the parent has to be told that he or she can revoke his or her consent at any time that they decide that they no longer want to agree to the use of prone restraint, should that become necessary. So consent is very important here, and it's spelled out in detail in the new regulations. So we talked a little bit earlier about that that the use of prone restraints, and certainly all physical restraints, are really only allowed in Massachusetts when there is an emergency. And so I want to talk a little bit now about what that really means and when physical restraint is permitted under the new regulations and when it's not. So it's important to note that when we talk about an emergency, that really does mean an emergency. It cannot be used as for staff convenience or as a punishment. It has to be used as a last resort to address an emergency situation. So for it is the general approach with the regulations is that it starts out with that physical restraints, including the use of prone restraint, is prohibited with some exceptions. And here are the exceptions. So again, we're talking about the general use of physical restraints. There are more restrictions on the use of prone restraints that we've talked about. But the general prohibitions for the use of physical restraint, again, are only when it's an emergency and only as a last resort. The exceptions of when a student could be subject to physical restraint is when he or she poses a threat of assault or imminent serious physical harm to themselves or to other people, and the student isn't responsive to verbal directives or other lawful and less intrusive behavioral interventions, or if those interventions are deemed inappropriate under the circumstances. So I kind of just want to break this out a little bit just so it's clear that the restraint is only going to be allowed when either you have the threat of the immediate threat of an assault or imminent serious physical harm. But the and is important. There has to be also the physical assault or the imminent serious threat of harm. It has to, or the student isn't responding to verbal directives. There has to be an attempt to use lesser restrictive interventions to try to help control the child's behavior before having to resort to restraints, unless those restraints would be deemed inappropriate under the circumstances. So it's really important to think about what other lesser restrictive interventions could be used, and it would be important to think about those things in advance. So those lesser restrictive interventions could be hopefully employed to avoid even getting to this point. But it is very limited when a restraint could be used, and it should be viewed that way. In addition, as I mentioned earlier, physical restraint, and that includes the use of prone restraint, cannot ever be used as a means of discipline or a means of punishment. Also, if it's medically contraindicated, it should not be used. For example, if a child has asthma, seizures, a cardiac condition, obesity, then those restraints should not be used if it would cause the child medical harm, if there's a risk. It also is not something that should be used to respond to property destruction or disruption to school. So, for example, children who talk back or to a teacher or yell at each other or just yelling and screaming, that alone is not enough to justify the use of restraint. Similarly, a student's refusal to comply with a rule or a staff directive, or where the student is making verbal threats when there's no threat of an assault or imminent physical serious harm. In cases where these other things are coupled, where there's a threat of assault or imminent physical harm, then restraint can be used, again, with the limitations that we've talked about. But these should be the last resort. Physical restraints also, and again, this includes the use of prone restraint, cannot be used as a standard response for any individual student, and they can't the use of physical restraint can't be part of a child's behavior plan or IEP as a behavioral intervention. So that means that it can't be that if a child has a certain type of behavior, for example, if he or she likes to leave class and run through the hallway, it cannot be part of the child's behavior plan that there will be certain interventions tried, and then if the the child does this behavior, for example, 3 times, then he or she is subject to a physical restraint. That would not be allowed, and that's actually not currently allowed under the current regulations either. If a physical restraint has to be used, then only reasonable force will be allowed to carry out the physical restraint, and in order to make sure that the student is not going to be harmed. And let's see, we'll talk about now.
Debbie?
Yes?
This is Janie. I just wanted to clarify something. We've had several questions come up around the same topic, and I think it's around the 2 different sets of regulations that I sent out prior to the webinar. They're asking if what you're talking about is specifically for just public schools, or can the private 766 schools be included in that? And if you could just clarify that. I know that there's a CMR 46 and a CMR 18.
Right.
So if you could just explain that, I think it would make a lot of other of the people understand what we're talking about.
Right. So we're talking about right now the regulations that we're talking about now, and since this presentation is just around CMR 46, I would say that it's important to look at CMR 18, but this governs the use of physical restraints on students in publicly funded elementary and secondary education programs, including all Massachusetts public school districts. That would include charter schools, virtual schools, and collaborative education programs, and the school day special education programs that are also approved under section CMR 2809. So I don't know if that helps to clarify, but
I think what people, I'm just getting the sense that people are asking about private schools, but I think they're referring to private residential facilities in particular, who are being funded by public education. So does it apply to those places also?
So in terms of, I don't know the answer to that question right off the bat. I apologize. I can find out, but I mean, it does cover again the programs that are elementary and secondary education programs that are part of the public schools, and so I think I would need to go back and look to make sure, but so I don't want to give I apologize, I just don't want to give any erroneous information.
Okay, we'll go with that, and so what we can do is maybe get in touch with the people that are asking these questions later on. Thank you.
Right, if you can take their names and contact information, I could actually get the information to you and then get it back to them, but I apologize, I focused on the on just 46 as it applies to the public schools.
Okay, thank you. Alrighty. Thank you.
Okay, so we are now still talking about the limitations of the use of physical restraints in public schools under Section 46 of the regulations. And so some additional limitations on the use of physical restraint, as you will remember, we've talked about when physical restraint is allowed, when it is prohibited, and considerations in terms of getting consent from parents. In addition, there's other very specific requirements that the new regulations set forth, which include that only trained school personnel can administer the physical restraints on students. So that means that if you have school personnel who have not been trained, they should not be doing any physical restraints. And that, for the obvious reasons, that students could be very seriously injured, and as well as the staff could be very seriously injured if you have untrained personnel doing the restraints. Also, when a physical restraint is being used, a staff person has to use the safest method that's available to administer the restraints. And the restraint must be terminated when the student no longer presents an immediate danger to him or herself. So, for example, if there's reason to believe that the immediate threat of danger is over, then that's when the child has to be released from a restraint. And there can't be, for example, a policy that says that the school holds, in all situations, holds the child in a restraint for a specific period of time, or no less than a specific period of time, because that would violate the regulations. A restraint also has to be terminated if the student is in severe distress. For example, if the child is having problems breathing or is sustained or having a prolonged period of crying or coughing, then the restraint needs to end. So that's, now that we've talked about restraints, Janie, I'll just check with you to see if there's any further questions about restraints before we move on to the definition of physical escort.
Yes, we have numerous questions.
Oh, okay.
So I think we're going to wait till the end, and I'll try to categorize them. Some of them are about training, which is coming up.
Yeah.
We'll continue, Debbie, because this is having a lot of people have a lot of questions. So
okay.
Yeah, I'll try and categorize them for you.
Okay, thank you. So in addition to some of the definition changes that we've talked about already, it's important to know that under the new regulations, the definition of physical escort has been modified as well. It's a more narrow definition than it was, and the reason for that is because the use of physical escort is now, because of the narrowing, is more limited, and it's limited to use for the use of a temporary touching or holding without the use of force of a child's hand, their wrist, arm, shoulder, or back, for the purpose of really inducing the student who may be agitated to walk to a safe location. And so it can't be used for a non-agitated student to force the child to move from one location to the other. And also it can't be used even for an agitated student where it can't be used in a way where the child is grabbed and forcibly pushed into an area, a different area, or pushed out of a classroom or out of a particular area. It is to help guide. It is a physical escort. It's to induce the student to move into a safe location. So that is one of the new differences in the definitions with the new regulations with respect to physical escort. Also, we talked a little bit about timeout earlier, because in the context of the definition of seclusion, and as you may remember, I pointed out that timeout is not considered under the regulations as the same thing as seclusion. Remember, I said that seclusion is a situation where a child is placed in a room, an area that's locked and the child can't leave, or is in some way that the child can't leave and is left unattended. A timeout under the regulations is considered a behavior support strategy in which activity or classroom, and the removal can be by a student choice or by staff direction. So a child may say, I need a timeout, I need a break, and be able to move out of the learning activity or out of the classroom to another area to take some space. Or a staff person in the school could direct the child to take a timeout. Again, there would have to be supervision, so there has to be continuous observation, and the purpose of it is to really calm down, and then the child comes back to the class or to the learning activity, either from which they were removed or the next learning activity if that particular activity is over. So it is really important to understand the difference between timeout and seclusion, because remember, seclusion is not allowed. Timeout is. So now we're going to move on to talk about safety requirements. And so that is in the context of what needs to be done to make sure that restraints, when they're administered, are done safely. So one of the first things that the regulations point out is that restraints cannot be administered in a way that would constrain a student's ability to breathe or to speak. Excuse me for one moment. My computer is about to... Okay, sorry, I had to fix my computer. Like I said, restraints cannot be used to constrain the student's ability to breathe or speak. And I was saying earlier that if a child is in a situation, for example, where they are unable to breathe, coughing continuously for a prolonged period of time, or crying for a prolonged period of time, then the restraint has to stop. So that's an important piece that's in the new regulations. In addition, the school staff have to monitor the student's physical status during the restraint, so that also goes to the point I was just making about the child being able to breathe, being able to speak, not coughing, not crying for a long period of time. And also another safety requirement is that if a restraint exceeds 20 minutes, then the principal's approval to continue the restraint is required. And all along the whole time, the staff have to be continuously monitoring the physical status of the student. And I just want to say that the examples that I just gave are not the only things that the staff should be looking for. There should be an overall monitoring of the physical status of the child, because there may be other things that happen to the child as a result of a restraint that would indicate that the restraint is hurting the child, or that the restraint needs to stop because it's medically contraindicated, which are not part of the list of things that we talked about. Those are just examples. Okay, some additional safety requirements that the staff who are working with kids who are or may be restrained are required to review and consider any, like I was talking about, any medical or psychological conditions that the student has that could be affected by the use of physical restraint. And I mentioned earlier, but I'll say this again, if there's a suspected trauma history, that could have, that could result in a situation where using the restraint could actually seriously exacerbate that trauma history. There are also times when using the physical restraint actually makes the behaviors worse, so could actually exacerbate the behavioral problems that the child has. So that's something that would have to be considered. Again, each child is an individual child, and so you really have to look at the kid as an individual, look at their histories, talk with the parents, and if they have outside mental health providers and the parents consent, it would be very important to talk with them about any conditions. Similarly, for any medical providers, to talk with them, again with the parents' consent, to get the information necessary so that when restraint does have to be used, hopefully very minimally, if at all, it's done safely. Also, it's important to look at any behavior plans that talk about any contraindications about using physical restraint as well. So those are some more safety requirements. In addition to that, we also have under the new regulations some important steps that need to happen after a child is released from a restraint, and so those procedures under the new regulations include reviewing the incident with the student, and then also reviewing the incident with the staff person who administered the restraint. That's also a piece as of what they would call in a psychiatric hospital a debriefing. There has to be a discussion when this review is occurring, a discussion of whether or not the proper restraint procedures were in fact used, and whether or not there's any follow-up needed for any of the students who might have witnessed the restraint incident, because that too could be very traumatic and scary, and so that has to be considered as part of the follow-up discussion that the school administration is having with the staff after the restraint. So now we're going to move on to talk about policies and procedures with respect to school restraints in public schools. Under the regulations, there are a number of requirements in terms of school districts having to develop and implement policies and procedures with respect to the use of physical restraints. So I'm just going to give you some of the highlights of what's in the regulations in terms of what needs to be addressed by school districts in their policies. Hopefully the school districts already have policies because there are already regulations around the use of restraints, but I would imagine that the policies are going to have to be modified, and as part of that there's going to have to be policies, for example, methods for preventing violence, self-injurious behavior, and suicide, and those policies per the new regulations are going to have to include components that address the issue of crisis planning and de-escalation. So that will have to be part of the new policies and procedures that school districts develop, or if they have policies, they're going to need to modify them to make sure that those things are included. Additionally, there has to be in the school's policies and procedures provisions to engage parents and guardians in methods not only with regard to what the restraint requirements are, but how to prevent violence and self-injurious behavior and suicide, and the crisis planning and de-escalation that I just mentioned. So it's important for school districts to make these policies and implement them to try to get parents engaged on those issues. So hopefully that will help to reduce the need for any restraint. There also has to be, as part of the policies, components that address what the school district is using in terms of alternatives to physical restraint and the methods of physical restraint in an emergency. So those are the things that we've talked about. The policies really need to conform with the regulations and should be clear when physical restraint is allowed, including when prone restraint is allowed, what's not allowed, and also the requirement that staff use alternatives to physical restraint whenever possible. The policies and procedures also have to include, under the new regulations, a statement that prohibits the medication restraints, mechanical restraints, and prone restraints unless they're permitted, as we talked about earlier, and the use of seclusion and improper use of physical restraints. So not only do the policies have to say when these things are allowed, but they also have to clearly say when the types of restraints that are never allowed that we talked about already, again, the medication restraint, mechanical restraint, and seclusion, and then the very limited use of prone restraint and when that is allowed and when it is not allowed, and also what is an improper use of physical restraint, which also covers the category of prone restraint as well. So all of those things need to be in the school district's policies. So I imagine that the schools will be working on those policies over the next year so that they will be ready for implementation no later than January 1st of 2016 and hopefully sooner. There also, in terms of policies, has to be a description in the policies of what the training is. And I know that some of you have been asking about training, although I don't know your specific questions. So maybe some of what we're going to talk about with respect to training will address those questions. But the policy does have to describe what restraint training is being provided. Also, it has to describe what reporting. As you may recall at the beginning of the presentation, I talked about that the regulations do require reporting of the use of restraints to the state and also to the parent when a restraint is used, and also a description of the follow-up procedures have to be in the policies. And we talked about a little bit of what those follow-up procedures needed to include in just a few moments ago. Additionally, in addition to all of the other policy components that I talked about just recently, just now, there has to be in the policies and procedure a procedure to conduct periodic review of the data and the documentation of the use of physical restraints. So this is really important because by gathering the data and the documentation of when restraint is being used, then the school district, not just the state, but the school districts themselves can, and the schools should be looking at the data and seeing, looking at for trends and looking at for different metrics to measure when it's being used, how long it's being used, and whether or not lesser restrictive alternatives were implemented and were they successful, why not, and really using this as part of their quality improvement and quality assurance to help reduce the use of restraints. There also needs to be a procedure for making sure that reporting requirements for the use of physical restraints at school are in fact met, and that means making sure that all of the documentation is done, it's done properly and timely reported. So those are some of the reporting and data gathering types of policies. There also has to be policies that address the issue of notice to parents and guardians regarding the use of restraints. And at the beginning of the presentation, we talked about the need for parents to have informed consent. And so the procedures that we're talking about here in these policies really need to address what type of consent, what type of notice needs to go to the parents, what informed consent actually means, and all of the different components of consent that are described in the regulations that we went over. Those all need to be part of the policies and procedures. Also, there has to be, if a school chooses to use timeout as a behavioral support strategy, then there has to be a procedure in place for the use of timeout, and so those have to be part of the written policies and procedures as well under the new regulations. All of these written policies and procedures that we've just gone over have to be available to all the parents and guardians so that they can have easy access to them and can understand them. In terms of parental notice of when a restraint has happened, I mentioned earlier that parents, not only does the state have to be notified of the restraint, but the parents have to be notified. And the regulations are clear in terms of what that notice requires. So this is different than notice to get consent to use prone restraint. This is notice for when a child has been subject to physical restraint, which would also, again, include prone restraint. And so one of the requirements, and this would all be in the policies that the school districts will have to write or modify if they don't already have them, is they must notify the parents and guardians of the use of a physical restraint within 24 hours of a restraint, or at least make reasonable efforts to do that. There has to be a written notification within 3 school working days of a restraint. So what 3 school working days means that if a restraint happens on Friday, then the weekend doesn't count because that's not considered a school working day, or if there's a holiday like we just had yesterday, that would not be considered a school working day. So it's the actual 3 days when school is in session. That's what a working day is. In case you're interested in measuring when that time would be up, the 3 days would be up. There also it should be noted that the written notification under the regulations can be done by electronic mail or by regular mail, which is postmarked within the 3 working days of the restraint. Not everybody has electronic mail, so especially in areas where there are less financial resources, so it may be that mailing and calling the parents may be what needs to happen, because electronic mail may not be something that's really viable in a lot of situations, although in many situations it will be. Then the final area that we're going to talk about, and I know that we're running out of time here, so Janie, if you need me to stop, just cut me off.
Debbie, actually, we were wondering if we could maybe extend a little bit because we do have some questions, but and we want to answer a few of them. But if you're not too pressed for time, we would love to have you continue. And
okay.
if people on in the audience can continue to listen, that would be awesome.
Okay, I think I can continue as late as 2 o'clock.
Oh goodness. Okay, that's great. Thank you.
Okay.
All right.
Okay, so now we're moving on, and I'm sorry that this is so long. There's just a lot of changes to these regulations, and there's a lot of details, as you can see. So there's the restraint reporting requirements, and I've mentioned those a few times already, but I want to focus a little bit on those now. The new regulations do require that that all uses of physical restraint are reported by the staff to the principal of the school where the school is where the restraint occurred. That has to happen verbally to the principal as soon as possible, and then in writing no later than the next school day. So remember what I said, the next school day is the day of school is in session. So if the restraint occurred on Friday, then assuming Monday is not a holiday, then the written report needs to take place on that Monday. If we had a weekend like this last weekend where we had a holiday, then the written report would be due on Tuesday. I want to note that even the verbal report to the principal, while that's required, that is not a substitute for the written report, so it's both. Additionally, all the restraint reports have to be maintained by the principal for review by the parent if the parent wants to see the report, and also the State Department of Elementary and Secondary Education, often referred to as DESE, also can request to see those restraint reports upon request. So they do have to be maintained by the principal of each school. And as we talked about just a moment ago, the parent and the guardian has to be informed of the restraint, and we talked about when that needs to occur as soon as possible, as reasonable efforts within 24 hours, but no later, but in writing no later than 3 school days from the time of the restraint. Other reporting requirements include that when there is a restraint report filled out, the reports have to include the names of the student and the staff who were involved in the restraint, the time the restraint began and the time the restraint ended, the name of the school personnel who were involved in the restraint. Also, there has to be a description of the activity in which the restrained student and others were involved just prior to the restraint, and there has to be a description of what the behavior was that prompted the restraint. In addition to those things, there has to be documentation of any de-escalation efforts that were used. That would mean any restraint alternatives that were tried, and also the justification for the restraint. So there's to really be explanation of what was tried and why that didn't work or wasn't appropriate, and what justified the use of the restraint. And that goes for all physical restraints, including the use of prone restraint. Additionally, there has to be a description of the administration of the restraint and the student's reaction, whether there were any injuries, and if there were, any medical aid that was provided. All of that has to be in the reports that are maintained by the principal for parental review and for DESE review. There also has to be information regarding any further actions that the school has taken or may take, including any consequences that are imposed on the student that resulted from not but from the behavior that led to the restraint. For example, you know, is the child going to be suspended as a result of that behavior, or arrested, any sort of disciplinary or other types of consequences that might be imposed, or any further actions may mean changing a student's IEP or other type of program. So there also has to be information about the opportunity for the student's parents and guardians to discuss the restraint incident with the school or any of the possible consequences that could be imposed on the student. So it's not just that you know, that information goes in the report, but there also has to be information that the parents are given opportunities to talk about these issues as well. So now on to training, because I know many of you are waiting for that topic, which is a very, very important topic. All of this is. So the new regulations also have a number of very important training requirements to help prevent hopefully the need for the use of restraint, and then if restraint is going to be used, to make sure that it's done safely. So all school staff are going to have to be trained with respect to the use of restraints, and all of the training has to occur within the first month of the school year, of each school year. And for employees who, there may be employees who start after the school year begins, and so they need to be trained within 1 month of their employment. So that's important to know. Make sure that that training happens. The training on restraint prevention and behavior support has to include a number of different components. So one of the things that the training needs to include is the role of the student, the role of the family, and the role of staff in preventing restraint. Because remember, this training is not just about how to administer a restraint, but how to avoid it altogether. And so the student, the family, and the staff all have a role in that. And so that has to be part of the training. In addition, the training has to include clear information about what the school district's or the school program's restraint prevention behavior, and the school's district or program's restraint prevention and behavior support policy and procedures are. So, for example, it would be really important for the staff who are receiving the training to understand the difference between timeout versus seclusion, and to understand that seclusion is not allowed, and to understand that while timeout is permitted, the staff should understand under what circumstances it is permitted and how timeout is to be administered. If a school district decides, or a school program decides, they're not going to use timeout, then they should make sure to be clear about that in their policies and in their training so that it doesn't get used. Although I think most school districts do use timeout. The restraint prevention and behavior support policy training also has other requirements under the regulations. So one of the other important pieces of the training, as you can imagine, would be what the interventions could be used that could help preclude the need for restraint. So other types of support interventions that would de-escalate the situation safely so that you never get to the point of the restraint. And then also it's important to make sure that the training and the regulations do require this, that the training include information, clear information on when a behavior constitutes an emergency that would require a physical restraint, and again, what physical restraints are allowed, and the safety considerations and those related issues. And those are all the things that we talked about. So the types of physical restraints that are permitted, the safety considerations are, for example, but not limited to, the psychological conditions of the child, the medical conditions, other issues like that. So all of that has to be in the training. In addition, there has to be a training on well, we talked about this, the psychological limitations and medical limitations of the use of restraint depending on the individual child. And it's important to note that that also includes that child's trauma histories because as we've noted, the trauma history could be exacerbated by the use of restraint. So that would be a consideration, and the staff have to understand that as part of their training and what to do. And there also has to be an identification of staff who've received an in-depth restraint training. The staff who are getting in-depth use of physical restraint training, the types of training that they have to get, while it doesn't, the regulations don't have a particular methodology that they're saying, or a particular training program that the school districts have to use. The regulations do set out the kinds of things that have to be included in the in-depth staff training regarding the use of physical restraint. And first of all, it has to be competency-based. It has to be 16 hours annually, and the content of the training has to include the appropriate physical prevention procedures and restraint alternatives that are allowed, identification of dangerous behaviors that may lead to the use of physical restraints. It also has to include a simulated restraint experience, and what that means is that a person who's going through this in-depth restraint training has to actually experience doing a restraint on somebody and actually being restrained as part of the simulated experience. There has to also be instruction on how to document the use of restraint and the reporting requirements and investigation of injuries. And those are all of the things that we talked about earlier in terms of what needs to be in a restraint report, when it needs to be reported, and the follow-up requirements that we talked about. So all of that needs to be as part of this in-depth restraint training. There has to be a demonstration by the individuals who are trained of their proficiency in administering restraint before they can be allowed to administer restraint if it becomes necessary. And there also has to be, as part of the training component here, instruction on the impact that restraints have on students and families. So that also is required as part of the training requirements. So that's just an overview. The regulations have fairly detailed. All of these things are fairly detailed in terms of what the training is and the reporting requirements and that sort of thing, as well as the administration of the restraints. In terms of next steps, as I mentioned, I think at the beginning, the regulations are not yet effective. They will not go in effect until January 1st, 2016. But that doesn't mean that the school districts can't implement them if they want to, because by implementing them they wouldn't be violating any current regulations or requirements, since these new regulations are actually more protective of the student than the current ones, and more specific. So you know, if at all possible, school districts can implement them sooner. That would be great, and we encourage them to do so if they can, but they don't have to until January 1st of 2016. Another thing that I think is really important in terms of next steps is that not only that school districts and school staff and anyone working in schools understand these new regulations and what is required, but it's important for parents and students, parents, guardians, and non-school community providers to understand these new restraint requirements. And it's, I think, really important to get that word out to people in advance so they will understand what the requirements are, what the limitations are, and what information they may want to get from the school districts when thinking about these issues, and making sure that they know that in advance rather than after a restraint occurs. I think that's always helpful to know in advance. If people want more resources, there are a number of places to go. The state is rich in many education advocacy groups around the state, and so we're really lucky to have that here in Massachusetts. The first place to go is the Department of Elementary and Secondary Education. I've added here to the PowerPoint the link where they have all this information about the new regulations, and you could actually download the regulations for this and also for the private schools in case you're interested in looking at those under Section 18. Those are available on DESE's website now. They were just recently posted, so you can go there and get those if you would like. If you don't have access to the web and need assistance, you can always call and ask me and I'll assist you. Also, another good place to get information is the Disability Law Center. They've been deeply involved in commenting all along the way on the development of these regulations and have done extensive work and are very knowledgeable, so they're a good resource. I work here at the Center for Public Representation, so that's another resource. And of course, the Federation for Children is going to have Visions of Community Conference, and I'll let Jamie talk a little bit more about that, but that will be on March 7th, where more information will be available. And Janie, I'll just hand that to you so you can talk a little more about that.
Thank you very much, Debbie. This is Paige Parisi from the RTSC program, and we really appreciate your going the extra mile, the extra 15 minutes with to finish up here. We do have a lot of questions, so I want to just say a few things, answer one question that came in multiple times having to do with the two sets of regulations, which is confusing. So everything Debbie has talked about today does apply to the day and residential special ed programs, 766 schools, any programs operated by public or private entities serving publicly funded students. When they passed the regulations, they made conforming changes to Section 18. Section 18 is a provision of the law that governs safety standards at these schools. So when they made these changes to the restraint regulation 46, they had to make some conforming changes to 18. So we can send you like a marked version that shows the exact changes to 18. There really weren't that many, but there's they have strike through and bold and underline that shows the new language. So we can send that out along with the slides after we wrap up here, so you can see the exact changes that were made to 18. But everything that you heard today all this wonderful information from Debbie does apply to those private schools. Now, a lot of these questions that you've asked, and we'll try to get to some of them, you know, they're going to be in the policies that the schools come up with, which Deb talked about. A lot of them will be tested. You know, these are new regulations. So, you know, I'm not sure we can answer all of these questions. We'll try to answer as many as we can. And then, as Deb mentioned, the folks from the Disability Law Center will be doing a workshop, a 90-minute workshop, at the Visions of Community Conference on Saturday, March 7th in Boston. That's the Federation's all-day conference that covers a whole range of topics. So if you're planning to attend that conference and you want to hear more about this subject, they'll go a little more in depth. It's the executive director of DLC and their director of advocacy. And DLC has sort of been the leader in Massachusetts on this topic. So they'll discuss more of the literature in the field, best practices for all of these things that we've been talking about, and some of the effects, traumatic effects, some of the risks of physical injury. So in addition to the regs, some of the things that we didn't have a chance to get into today. So I'm just going to scroll back and pick out a few questions. Okay, Debbie?
Okay.
Okay, great. So in the category of mechanical restraint, does the restraint necessarily have to be placed on the child to be included in the category? For example, would the use of a blue gym mat to block and surround the child fall into this category?
That's an interesting question. I mean, it really is. I can tell you that the definition, and this may be a question for Desi, although to me, I would say that it is a mechanical restraint, because the definition of mechanical restraint, just reading right from the regulations, is that it shall mean the use of any device or equipment to restrict the student's freedom of movement. So I would say the answer is that use of a gym mat to restrict the student's movement would not be allowed, because that would be considered a mechanical restraint. Yeah. I would argue that.
Yeah, I would agree with you. I think any parent or advocate could definitely take that position with the school. Is it considered seclusion if a child is in an area of a room and prevented from leaving that area or corner of the room with a waist-high barrier if the adult is on the opposite side of the barrier than the child? In this situation, the child and the adult are in the same room. Yeah, these are. I mean, this is all new ground.
Yeah. Right. And you know, I mean, these will certainly, I'm sure, be debated between advocates and other folks. But I mean, you know, the definition of seclusion, what it says is that the child would be involuntarily confined in a room or area from which the student is physically prevented from leaving. So. Again, if it sounds like there's a barrier there and the student is in fact prevented from leaving. So to me, I would argue that was seclusion.
Okay. Let's see. So the area of consent that you talked about, does that only apply when you're talking about prone restraint?
In terms of the regulations, certainly the way in the definition section, if a parent doesn't consent to the use of restraints under the definition of restraint in the new regulations, that can't be a reason not to allow a child to be admitted to a program or continue to be in a program. My understanding, and Paige, you can correct me if I'm wrong, is that in order to use a prone restraint, a prone restraint cannot be used without a parent's consent, whereas a physical restraint could be used in an emergency situation, but not a prone restraint. But
I would agree with you. I would agree with that answer. Is it possible to put a statement in the BSP or IEP that indicates that if there is a risk of serious physical harm and when all other strategies have been ineffective, that physical restraint will be used, and have that be consent for restraint?
You know, that's, I don't know. I really think that's putting my advocacy hat on, which I wear all the time. I would say I would really oppose that if the school district wanted to put that in a behavior plan, because I think that that will lead to the use of restraint, and I think that that it takes away from considering other alternatives and could be viewed as part of a continuum of interventions that's part of the behavior plan. And so I would really, personally, I would object to that quite a bit. Whether, you know, I don't know, Paige, if you have a thought.
No,
on that.
I think you're correct in that this was debated during the development of the regulations. The IEP part of this question for sure was debated. I can't recall off the top of my head if the behavior plan was also part of that discussion. And I'll take a look back at the regs and confirm this, but I do believe that it is specific that this can't be part of an IEP.
Right, and I think it's also cannot be part of a behavior plan either. Like that it can't be, that you can't say, you know, we're going to do this, this, and this. As I heard the question, it sounds like the person is asking, like, well, can they just have a statement that if there's an emergency situation? And I would personally, if I'm the advocate on the other side of that, I'm going to object to that.
Right, for the reasons that you stated.
Yeah, yeah.
Mm-hmm. Good. So someone recalls that you said staff must consider behavior plan regarding use of physical restraint as safety measure, but was confused because he thought physical restraint can't be, the similar question, can't be part of a behavior plan.
Right, right, and I apologize for confusion about that. That's correct. It can't be part of the behavior plan, but there may be other things in the behavior plan that like, for example, it may be that a child has a trauma history, and the trauma history may be spelled out, you know, in terms of behavioral supports to help support the child positively around the trauma. That may be in the behavior plan. So what I meant to say was that if you look to the behavior plan, that may give information about some risks of using restraint. That's really what I mean. So okay. I'm sorry for the confusion.
No problem. You know, it is not easy to take in the first time. Here's another question about seclusion. Is it considered seclusion if a student is in a timeout room with door closed, with staff having visual through a window?
Yes, that's seclusion.
That's seclusion. Yes, I agree. And what if the door is open?
Well, are they physically prevented from leaving?
So that's not part of the question, but if they are,
have a door open and a big staff standing there and not letting the kid out, and to me, that's seclusion. And
right.
then certainly in a psychiatric hospital, that would be seclusion. Even if you put somebody, you know, in their own bedroom and don't let them leave, or put them in in part of the classroom, you know, and don't let them leave, and that would be seclusion. So it's just confinement where they can't leave.
Okay. So is it? So here's a question: Is a timeout room door a mechanical restraint?
Interesting question.
Mm-hmm.
I suppose on the face of the definitions, it could be, but they're both prohibited. So, you know.
Okay.
With the seclusion, I mean, timeout is not prohibited, to be clear, but seclusion is. And if it's like a seclusion situation, then I mean, with the timeout, then the student is continuously observed, and the student shouldn't be involuntarily confined to that area alone.
Okay, so let's take one more question. Do all staff or only staff who may be likely to use restraint have to be trained?
I'm sorry, could you repeat the question?
So do all staff or only staff who may be likely to use restraint have to be trained?
No, all staff. My understanding from the regulations is that all staff have to have the training, and then there is the in-depth staff training that we talked about, and that is for the staff who are going to be sort of on this school-wide, to serve as a school-wide resource in ensuring the proper administration of physical restraint. So there's two levels of training. There's the training that's required for all staff, and then there is the in-depth staff training, and those in-depth people are going to be the, provide sort of the maybe mentoring and guidance to other staff who haven't had the in-depth. They're the ones that would help make sure that the other staff, in case they become involved in a restraint, are doing it properly, and and also how to avoid it. So there's the two level of training. I don't know if that answers the question.
I think it does, and very thoroughly. And I wanted to say thank you again, and I think on behalf of everybody who's been part of this call, we had a really large number of people who signed up, and many of them